Okay, thank you. Kathryn, I think, just stepped away. I'm going to get started and she'll get back online fairly quickly. Daniel, I appreciate being here, and I am really, it's always really helpful when Jim Bradbury goes first because he gives you such a great overview of conservation easement information, and it enables Kathryn and I to drill down on some more specific topics. And so we're going to talk today principally, we're going to focus on some of the tax benefits and then some other financial considerations, and that's going to relate in large part to transaction costs. I'm going to make sure that we give some time at the end so that you can have your questions and we can have a little discussion. And I do want those questions to be broad. If you still have some ideas kind of left over from Jim's discussion, Kathryn and I are completely able to help and answer those questions as well. At the end of Jim's discussion, you were talking about what to expect in the next legislative session, and he mentioned the TREAD Coalition, and I do have a website for that, and at the end of this speech I'll go ahead and put that on the chat so that you have a link to see if you want more information about the TREAD Coalition, which is a coalition of landowners working on rural landowner issues. Okay. Real quickly, Kathryn and I, like Daniel said, are from Braun Gresham. Braun Gresham is a law firm really dedicated to helping rural landowners, and we're also affiliated with Plateau Land and Wildlife and Plateau Land Group. I'm going to focus, like I said, on tax benefits today. And I just saw Kathryn come on the screen. Before I get started, Kathryn, did you want to just say hello?
Yeah, thank you everybody for having me here. Margaret's going to focus on the tax benefits, and then I'll talk about kind of the difference in available options for selling a conservation easement as well as donating, and then getting our transaction team together, some of those transaction costs as well. So thank you very much.
Sure. Thanks, Kathryn. You know, I say to a lot of people that, you know, you don't donate a conservation easement simply for the tax benefits. I think when my clients do a conservation easement, it's because they have a conservation ethic and they have some strong personal reasons to preserve the land and often preserve their family's legacy, or have an opportunity, if it's newly acquired land, to them to make a difference in the community. But those tax benefits are really important, and they help it be the type of transaction that can help the family quite a bit. And so I'm going to go over principally income tax benefits, because those are the largest benefits. So you do, if you do a donation of a conservation easement and you comply with the requirements that are necessary, ones that IRS sets forth, then you can qualify for an income tax deduction. And that's what we're going to focus on today. But other tax benefits are that you do end up having a lower appraised value of the land in the estate, because by giving up the development rights, you have given up a significant portion of the value. And so if you have an estate that's starting to bump into estate tax territory, this is one of those tools that we can use to help reduce the state and avoid federal estate tax. There could be some property tax relief, especially if you're going from some kind of market value and through the conservation easement, you're doing more habitat management and wildlife. And in some states like Colorado, there's actually a tax credit. Those latter ones are kind of beyond the time we have today, but they're good to keep in mind, and if they apply to you, worth researching. So I want to just go over an example of how we value the CE so that we know how we get a number for the tax deduction. So the value of a conservation easement is the difference between the fair market value of the land at its highest and best use and the fair market value of the land after you put all those easements, rights, and restrictions on it. And so highest and best use is really important. If you're land is close to an urban area, then its highest and best use starts migrating toward being a subdivision. And if you give up those subdivision rights, then you have changed the value significantly. And so my numbers today are all hypothetical numbers to help us kind of understand the value and the income tax consequences, but I just wanted to introduce them here. So let's assume we've got a piece of rural land that's near an urban area, and it's worth $8 million in its highest and best use, and that's if it can be sold, likely to be a suburban subdivision. If you put a conservation easement on it, and depending on what the restrictions are, today I'm assuming that it caused a 40% reduction in value, so that the land is now worth $4,800,000, sorry, instead of $8 million. And so what that gives us is $3.2 million as the value of the conservation easement. It's that difference. And that's going to be what your charitable donation is. This is assuming a fully donated easement. This slide now starts giving you an idea of how that donation affects and your tax savings. I'm going to assume that the donor has a very good AGI, adjusted gross income, of $250,000. And at that rate, they're taxed at 24%. Then we're going to have our donation. It's $3.2 million. It's the charitable donation that the donor made. And they get to use that donation by applying, I'm trying to phrase this right, by taking a credit of up to half of their adjusted gross income each year. So out of that $3.2 million, in the first year, they get to claim $125,000 as a donation on their income tax. And that's going to reduce the adjusted gross income to $125,000, which actually, for starters, puts them in a different tax rate. And their tax savings is going to be, in my hypothetical, about $30,000 a year. And what's really unique about a conservation easement is after the first year, you still get 15 more years to carry over your tax deduction and to keep using it. If this were a straight donation of land to a charity, like I'm leaving a portion of my land to the local hospital, then you'd only have a 5-year carryover. But conservation easements have an extended carryover of 15 years. And so you get a total of 16 years to use that deduction. So my assumptions, like I said, are hypothetical. We're assuming that the donor has that $250,000 AGI every year for 16 years. Their total tax savings is going to be $480,000. But because they can only use $125,000 a year, they're still going to have some unused deduction, and I calculate that to be $1.2 million. So they'll have used up $2 million of their tax deduction over 16 years, but they're going to have some left over, and we're going to talk about that in a couple minutes. Now, the tax code treats a qualified farmer or rancher differently and considerably better. And so to be a qualified farmer or rancher, you have to be deriving 50% of your adjusted gross income from farming and ranching activities. But if you've made that qualification, then you can apply the deduction to all of your AGI. It's a 100% AGI deduction. And so in that case, each year, that donor who's a farmer or rancher is able to reduce their taxes by reducing their adjusted gross income to zero, giving them an annual tax savings, in my hypothetical, of $60,000 a year. We get 16 years to use it, your 15-year carryover, recall, and they have a total tax savings of $780,000. And if you notice at the bottom, in this case, the deduction's used up in about 13 years. So they got all the way through that $3.2 million. One of the things some of our families ask us to do when they're donors is say, ooh, you know, I see that I'm going to get this great deduction, but I really can't use it. I'm retired. I don't have a huge adjusted gross income. And so is there any way that I can help other family members benefit from this? And one strategy is to before you make the donation, to create a business entity and hold the land in that business entity, and then gift some of those entity shares to other family members. So in this case, here's our example. Mom and Dad landowner, they form Family Ranch LLC, and they transfer all the rural land to the LLC. And then they make a gift of LLC interest, 48%, to their 2 children. So they're retaining 52% in this hypothetical, so they can retain control. There's other ways to retain control as well, like making voting shares and things like that. Now, you got to keep in mind that this gift of the LLC interests, and you've got an LLC holding an $8 million piece of property, is going to create a gift tax event. That's going to be a gift that is reportable on a gift tax return, and in our situation, it's subject to the gift tax unified credit, which right now is over 11 million per person. So it will use up some of the gift and estate tax credit, but it likely won't trigger a gift tax obligation. The children, as the members of the LLC, then have the opportunity to participate in that charitable deduction that's received from donating the conservation easement. And here's kind of an example of how those numbers work. So Mom and Dad, in our hypothetical, had the $250,000 annual income. They own 52% of the LLC, and so they're getting 1.6 plus of that deduction. Given the kind of calculations I showed you earlier, they're going to be able to use up all of that deduction in 13 years. And of course, my hypothetical assumes a level income that whole time. Then they have another child, and she's in tech, and she's making all kinds of money, and she's got a $400,000 annual income. She's now a 24% owner of the LLC, and she's going to get $768,000 of that deduction. She'll be able to use that up in 4 years. Then we have another child doing very well, $150,000 annual income. He also owns 24% of the LLC. He gets that same 768 and is able to use all of it in 10 years. So this is a situation in which, instead of leaving 1.2 of the deduction kind of unused, the whole family was able to benefit. Now, when you do gift shares to your children, it's not simply that you're incurring a gift tax, but you are kind of creating this family company and more people that are involved potentially in decision making. But it's also really a great opportunity to get your younger family members involved in managing the ranch and being stewards. That, I think, is all I've got, because I wanted to respect our time. And I'm going to pass it on to Kathryn, and then if you have questions about the tax consequences, we can talk about those at the end.
Thanks, Margaret. Margaret just went through the tax benefits of donating a conservation easement, but sometimes there are specific funding sources available for the purchase and sale of conservation easements. Some of the examples of these programs include the City of Austin, Travis County. There are also federal programs. The Great American Outdoors Act just recently passed, which will guarantee funding for the federal government to obtain lands for conservation easements as well. So just wanted to make everybody aware that there is the opportunity for the sale of conservation easements as well as the donation of conservation easements. On some of these deals, when there is a sale, sometimes the entire purchase price is not available. So what you can have is a combination, which is referred to commonly as a bargain sale, where a portion of the conservation easement value is paid for, and then a portion of those real estate interests are donated to the easement holder. Okay. So in order to basically put together some of these conservation deals. It takes a lot of different professionals, and we like to refer that to our transaction team. So, number one, you've got to have an easement holder, a land trust, a government entity, some organization that is qualified under state law and federal law to hold conservation easements. You've got several of those on this program today. The next step, of course, is determining what the value of the conservation easement is. And so the individual who does that is a conservation easement appraiser, and they will look at the property, have an on-site inspection, figure out what the value of the property is, the fair market value of the property is prior to the restrictions in the easement being placed on the property. And then they'll also determine what the restrictions or what the property is worth after those restrictions have been placed. And that's where you might be hearing this before and after value concept. And then once you have the before and after, it's a simple subtraction problem, and then you're left with the value of the conservation easement. So our appraiser is very, very important. You also need a baseline documentation report, which gives you a snapshot of what the property looks like at the time the gift or the conservation easement is sold. This document is used by the land trust or the easement holder to ensure that the restrictions and terms included in the conservation easement are upheld on the property and can be used for monitoring and enforcement purposes into perpetuity. We also, as landowner representatives, view this document as very important for the landowner as well. It helps the landowner to know and remember exactly what the property looked like at that time, and can also help them have those monitoring and enforcement conversations with land trusts. In addition, when landowners or grantors of easements, perhaps they transfer or convey the underlying fee simple to the next landowner, and then again, that baseline report would be very important for the subsequent owner. Sometimes you don't have to have a survey for a property, but oftentimes, especially if you're dealing with a government entity who's purchasing a conservation easement, it's good to know exactly what area or configuration of property you are conveying, and the survey can help us do that. The IRS doesn't specifically require it, but it is a best management practice from my perspective, and I'm sure many of the people here would maybe go even a little further than that. But we also recommend to our clients that if there hasn't been a recent survey, that we get a recent survey so that the legal description is accurate. Sometimes too, you might have a parent tract of property and want to convey an easement on a portion of that land, and the survey can be helpful in that scenario as well. Lately, I've also been making sure to put the building envelopes, not necessarily meets and bounds descriptions, but including the configuration of the building envelope, maybe pinning it with a coordinate on the corner on a survey, so that the IRS doesn't view those as floating, and the landowner and the land trust can know where that is located. Sometimes, in order to substantiate the appraisal values, a land plan can be useful. For example, if you have a ranch that is 500 acres and there's a lot of water and creeks and features on the property, you might be able to divide that ranch up into smaller ranchettes, and the appraiser would benefit from being able to see that document. So sometimes if you are planning on doing something with the property, you can use a land planner to kind of substantiate what could be possible, even though that's not what's going to happen after the conservation easement is recorded. But that's not always necessary. Very important are our CPAs and financial planning professionals. There are significant consequences and benefits to these transactions, and it's important to have qualified financial advisors involved as well. So we always appreciate it when our landowners have a CPA who is familiar with conservation easements. Sometimes they're not always. They are still relatively new concept in some professions, obviously not ours. And then of course you have your legal team, attorneys, things like that. And again, I think that this also includes the land trust and the other entities on the other side of the transaction. Margaret?
Yeah.
Okay, so those are a lot of professionals, a lot of professional fees. So I think one question that we always get from landowners is, how much is this going to cost, or what is it going to take in terms of resources for the landowner? You know, one very important item is that when you donate a conservation easement to a land trust is often asking for a stewardship contribution or an endowment. Every land trust has their different way of calculating what that amount would be in order to properly monitor and enforce the conservation easement restrictions into perpetuity. Some of the factors that are considered there are how far is the property from headquarters, you know, things like that. The appraisal costs, the baseline, typically that's, depending on who you obtain for an appraiser, it can be on the lower end, 5,000 maybe even, or it can be on the higher end if it's a bigger property with more complex issues. For example, if you are retaining a piece of property from that parent tract that's going to be on the outside of the easement, there might be some enhancement analysis that need to be done, and that appraisal might become more expensive. Or if there are several different ownership entities, things like that can drive up the cost of an appraisal. The baseline report, typically the land trust will do those in-house, and some land trusts will ask for those costs to be reimbursed. Some will do more fundraising to cover those kinds of costs and staff time. And the landowners very much always appreciate when the land trust does take on that responsibility. But sometimes the landowners are can benefit from having an independent contractor basically do the baseline report. We've had that happen a couple times, but most of the times it's the land trust that's going to be paying for that, or absorbing those costs rather. The landowner is often asked to provide a title policy that would benefit the land trust or the easement holder, ensuring the title interests of the conservation easement that is conveyed. That title policy is proportionate to the sales price or the appraised value of the conservation easement. So sometimes, again, depending on how much that property or interests are worth, it can be, you know, as little as 5,000 or as much as 20,000, depending on what the conservation easement is worth. Surveys, exhibits, again, those are just specific costs that would be involved if a survey is needed. Mineral remoteness letter, if the mineral rights are determined to be severed from the current owner as shown in the title report or commitment, then the IRS requires that a certified geologist look into the ability of whether those minerals can be developed. That's because the IRS requires qualified real estate interests to be conveyed in order for the contribution to qualify. So a geologist would need to look at the property and make a determination as to whether the ability to develop those minerals is so remote as to be negligible, which is the legal standard. And those letters, you know, if you get them early enough in the year without having to expedite them, you can get them from $1,500 to $2,000. Environmental hazard reports, if there's a purchase easement, a government entity will want to do an environmental phase 1 to make sure that they're not acquiring a an environmental liability, that there's not some dump or chemicals that have been deposited on the property. Typically, the government entity will pay for that report, given that it's really up to them to make sure that that's, that it's their responsibility. They kind of want the report to be addressed to them so that they are comfortable with that. Closing and recording costs, those are usually typically minor, but there are costs for actually closing the transaction. And then we've already kind of talked about those other things, and of course the professional fees. So I'm not sure, I think that's probably good enough. And if there are any questions, we're happy to answer them. So thank you again for having us today.
Yeah, so this last slide is just to inspire y'all in case you didn't have any questions for us. One thing I wanted to add after Kathryn talking, when she talked about the sale of a conservation easement, and she mentioned that it's usually a bargain sale. It really is. It's usually you have some compensation for the conservation easement and you're also making a donation. So in those situations, you've still got that donation, which is going to help you with taxes principally in the first year, because with the sale of the conservation easement, you've got a fairly large income event. And so I just wanted to mention how those interact, because I focused a lot on the carryover if you're doing a straight donation. But our experience, and it could be different, is that if you do a sale and a bargain sale, then most of the time, much of the donation is used up in the first year or the first couple years. So Tiffany or Daniel, I saw that you kind of received questions by chat. How can we answer some questions for this group?
Yeah, we sure did receive a few. Let's see, one of them is it worth creating a conservation easement on a long, skinny 22-acre property if the land on either side is not under a conservation easement?
Kathryn, you want to take
that? Sure. So I'm not going to answer that question exactly because I don't want to provide any legal advice today. That's my caveat. But I think that, 22 acres, I'm just going to say it, is pretty small. So in order to have a conservation easement qualify for the tax benefits, you have to have conservation purposes of the easement. And for example, you have to be conserving significant or relatively natural habitat, things like that. So I think that the question of whether that particular piece is worth conserving, and don't get me wrong, I think every single acre is worth conserving, no matter how small it is. But you would have to find an easement holder that would be willing to take that property. But lately I've seen easements more starting at the 100-acre range. But again, if this particular piece has a recharge feature on it or a sinkhole or something like that, then there may be an argument or a land trust that wants to hold that piece of property.
So it sounds like, Kathryn, that maybe the other thing is, what can a landowner do if they have a small piece of property that they care deeply about, that they think is something they'd want to preserve, is like a first step for them to reach out to the land trust community and maybe get people out there to walk it with them and kind of understand what the conservation resources are?
Yeah, absolutely. And, also don't be deterred if you can't find somebody that's interested in holding that easement. There are other mechanisms under the law, such as restrictive covenants, that can protect land. They're not as restrictive covenants don't protect the land in perpetuity, but there are other options for conserving a piece of property. And the land trust can talk with you about what their concerns are, whether they're interested, and then we're always happy to consult with people individually looking at their specific piece of property, as well as far as their conservation options that are available to them.
Yeah, I agree. In all of these questions of is a piece of property too small, the answer is pretty much always it depends, and it depends on if you can find a partner. So I'd encourage folks to reach out to a couple or 3 land trusts, talk to them about their personalities, sort of what interests they have. In some cases, you know, on the other side of the country, a 22-acre conservation easement is fairly large. So, so it depends, but I definitely encourage as well reaching out to your land trusts. So we have, that brings up another one. To what extent is this seminar information specific to Texas law versus federal and maybe county, et cetera?
So my piece about taxes is really focused on the federal tax code because it's your income tax charitable donation. As I mentioned, I think depending on the state you're in, you should get to know, you know, are there other tax benefits to us? As I mentioned, Colorado can give you a tax credit if you're preserving land there and you're also paying income taxes in Colorado. But I would say a lot of this is driven by federal law. Kathryn, your answer might be a little different.
Yeah, I mean, I think too, you know, in order for a conservation easement to qualify for the federal contribution, the conservation contribution, it has to be valid under state law. So I think, you know, it really, you know, everything that I'm saying, I'm licensed in both Florida and Texas. So, you know, particularly I'm talking to a crowd here today that's from Texas. So I would say that everything I've said is specific to Texas and federal law, as well as basics from other states such as Florida. So it, you know, when you know, we kind of kept our presentation a little bit broad today. So when you get into into certain specifics, that's where you're going to find that differentiation really important.
And we have one last comment / question from Ryland Howard here about a needed provision in wills, trusts, and entity agreements to allow executors, trustees, and partners to enter into conservation easement. That can be a major estate planning consideration, and that otherwise we may not be able to execute the CE. Margaret, do you want to tackle that? Or
yeah, so I am, you know, I do conservation easement work, so I'm principally an estate planner, and because a lot of our clients, as they're doing their estate planning, conservation easement is a big component. And I agree. So what I think I'm just kind of going to repeat the comment is, as you're doing your estate planning, and often if you have like a revocable trust for your estate plan tool, or you have a will, one of the things that you want to think about, if this is something in your future or something that's important to you, is empowering that executor or that trustee to do a conservation easement transaction. And that's kind of in the event that you didn't get it done. And one of the reasons it's important for that to be specific in the trust or the will is because we talked at the beginning, the conservation easement transaction, if you look at it just on paper, actually devalues an asset. It takes some, it gives some of the value away. And I think there's been concerns at times when you have a trustee that doesn't appreciate the goals and the importance of the conservation easement, that they're going to struggle saying, well, I have a fiduciary duty to the beneficiaries. How can I devalue an asset? And so what we like to do, and what I do in my documents, is I specifically authorize the donation or sale of a conservation easement by the executor or trustee to effectuate your long-term plans, and so that trustee's not having cold feet.